as Rachel said, my name is Ann Manginelli. I'm the managing attorney of Legal Aid's Health Education and Law Project, or our HELP project. And what HELP does is we partner with hospitals. Most of the hospitals in Omaha, we're in Grand Island, we're in Kearney, we're in Columbus, and we're in Lincoln. And I have attorneys that are in-house at the hospitals one day a week when there isn't a pandemic. And we meet with patients in their rooms and help them with any sort of legal issue that we see is somehow either inhibiting their health or inhibiting their access to health. We include in this powers of attorney and advance directives because we do a lot of guardianships. And I would like to stop doing guardianships. And if people would do advance directives, then there would be decision makers in place and I wouldn't have to do so many guardianships. So we do advance directives. In this presentation, I'm going to talk about several kinds of advance directives. I'm going to talk about financial powers of attorney, healthcare powers of attorney. I'm going to talk a little bit about living wills. And then at the very end, I'm going to talk about a new healthcare power of attorney that the legislature just passed this year, which is the mental health healthcare power of attorney. And I'll talk about that statute. And I'll also talk a little bit about the Surrogate Decision-Making Act, which was passed a couple of years ago. So there's a lot kind of crammed into this hour. I will leave, I sometimes talk fast, so I may get done early anyway, but I'll leave time at the end to ask questions. So a definition of power of attorney, and this is all powers of attorney. It's a document whereby the principal, which would be me, if I'm drafting and I'm saying I want to appoint somebody, I'm the principal. And I authorize another person, the agent, to make decisions and take action on my behalf. So I'm going to be talking about principal and agent through this entire presentation. I think it'll make it a little bit easier if I just say that I'm going to be the principal. So I'm going to be the one that is drafting this advance directive, and I'm going to appoint Rachel to be my agent. So Rachel's going to do things under this. Instead of trying to keep track of principal and agent, we'll just say that I'm the person who's writing it, and Rachel's going to be my agent. So who can designate an agent? I can designate someone as long as I am in the state of Nebraska, 19 years old. Nebraska is one of 2 states that has the age of majority at 19. Every other state in the country is 18. It causes all sorts of problems with the 19. Not sure why they haven't changed it, but so in Nebraska, you have to be 19 years of age to do a power of attorney, and you have to have capacity. People throw around the word capacity and competency a lot, and they aren't really the same thing. Capacity means that a person is capable of making the kind of decisions that they need to in order to understand a power of attorney. So they have to understand what's in it, and they have to understand the consequences of making those decisions. So not only do I have to understand what it is that I'm signing, say that I'm giving somebody the ability to make my medical decisions, I also have to understand what it means by doing that. That's capacity. Competency is actually a court ruling. So I can lack capacity, but I still have competency unless a court says I don't. So if a court has ordered and made a decision that I am no longer competent, then I lack competency, and that makes a difference in these documents. So I'm going to talk for the most part about capacity because that's what you need to have in order to sign these documents. Okay, so healthcare powers of attorney, financial powers of attorney, and living wills. As I said, I'll get into the mental health powers of attorney and the Surrogate Decision-Making Act a little bit later. So I'm just going to deal with these right now. What are they? Why do I need them? A living will. So a living will basically tells your physician what you want done if you are in a state, a permanent vegetative state, and not expected to live. It isn't appointing somebody to make your decisions. I'm not saying, this is what I want Rachel to do if I'm in this position. It is actually something that you sign telling your physician, if I'm in this state, this is what I want and what I don't want. I don't do a lot of these. I typically do powers of attorney, and I'll come back to this in a moment. So financial powers of attorney, what financial powers of attorney do is they appoint somebody to be able to do your financial stuff. while you're in the hospital, while you're unable to do things, they're able to pay your rent. They're not with their own money, but with your money. So they can write, depending upon what kind of power you give them, they can write checks on your account. They can find out what bills you have and take care of all of that stuff. The healthcare power of attorney appoints someone to make medical decisions for you. It says when the principal cannot, and what that means is when the principal lacks capacity. And that can be any reason, from you're in a coma, or you lack mental capacity, that something has happened where you suddenly do not have capacity to make your decisions, whether it's physically or because of something. Dementia is one of those things. So those are the three kinds of powers of attorney or advanced directives when we're talking about that. The reason I do like living wills is because living wills can kind of help your power of attorney to make decisions. If you have a living will and you say, this is what I want in this circumstance, and it gets to that point, that's going to be instructive to your healthcare agent. Rachel's going to have a better understanding of what I want because I have this living will that in writing says, this is what I want. So although you don't need a living will, that's what I see them being best for, is to be instructive for your agent when you come to those decisions. So why do I need these? Why do I need these documents? Up until the Surrogate Decision-Making Act, which allows people to make medical decisions when someone does not have a guardianship, does not have a guardian or an advance directive, up until that time, there was no statute in the state of Nebraska that allowed someone to make medical decisions if the person couldn't. Now, the Surrogate Decision-Making Act goes a long way in helping that, but it doesn't allow anybody to do anything financially for you. It only covers medical decisions, and there's a lot of steps that people have to go through to decide who's the right person to be making decisions under that act. So why do you need these? You need these so that if you're hit by a bus and suddenly you're unconscious, your family isn't sitting in the emergency department trying to figure out, okay, who's going to make the decisions? What decisions are we going to make? The doctor's asking us a lot of questions. I don't know what so-and-so would want. Do you know what so-and-so would want? And even if you have the answers to those questions and can make those decisions under the Surrogate Decision-Making Act, if you don't have a financial power of attorney, as long as that person is in the coma, no one's paying their rent, no one is paying their car payment, nobody's paying for their cell phone. So if they do come out of the coma, they are suddenly behind on all of their bills. So I always tell people, you aren't doing advanced directives for yourself. You're doing them for your family. You're doing them so that your family knows exactly what you want, who you want to make the decision, and has the ability to have someone do those things if something should happen to you. When I'm talking to groups, I do a lot of talks to like the Alzheimer's Association. And, it's hard for those individuals because people see advanced directives as I only need these end of life decisions. And they really aren't. They really are for things that happen. For instance, I had one patient who was starting chemo. We did the advanced directives, and the first chemo he got just did not sit well with him. And there was about a 2-day period of time where he lacked capacity to make his own medical decisions. Because we had done healthcare power of attorney, someone else was able to make those decisions until he was able to make the decisions again, and then it was fine. I have 2 adult children. One is 24 and one is 21. They both have advanced directives. As soon as they hit the age of majority, because of the things that I've dealt with in my practice, I made them both execute them. So we have them and they're in our safe. So that's why you need them. So let's go a little bit more into the financial power of attorney. The financial power of attorney does not take away my ability to do anything. So if I sign a financial power of attorney, it doesn't mean that I can't go to the bank and sign checks. It just means that Rachel can also go to the bank and sign checks. It is a document that goes live the minute I sign it. So unlike a healthcare power of attorney, which isn't valid until someone loses capacity. A financial power of attorney, at least in the state of Nebraska, is a document that is live the minute I sign it. So let's assume that I'm in the hospital, I'm awake, I'm cognizant, I have capacity, but I'm really, really sick and I can't get to the bank. I have checks coming in. Even though I can make my own decisions and do things, because I've appointed Rachel to be my power of attorney, Rachel can take things over to the bank and she can sign checks and she can take care of my financial stuff while I'm in the hospital. And so you can really tailor this. So say I don't really trust Rachel, she's a little shady, and I just want her to be able to take $500 a month out of my bank account to do something. These can be tailored in such a way that you can give as much or as little authority to the power of attorney to do things on your behalf. So they're good documents in that way. If you don't really want to give the person the keys to your house and allow them to do everything, you can really limit what they can do, but give them enough power so that they can really take care of your stuff while you're ill. So that's the financial power of attorney. So validity. Let's talk about validity. For a power of attorney in general, it has, in order to be valid, it has to be validly signed. And I will tell you that one thing that I get all the time is I will get doctors who will email me powers of attorney and say, this person did this thing 20 years ago. Once they're valid until they're revoked. So I don't care if it's 20 years, 30 years, as long as the principal is still alive, the agent is still alive, and there hasn't been another one that revokes it, it's still a valid power of attorney. So for a healthcare power of attorney, you have to have either a notary or two witnesses. You can have one witness can be a healthcare provider, but only one of the witnesses. We typically do it by notary because when we're doing powers of attorney, since we're there anyway, we usually notarize the document. But it can be either two witnesses or a notary for the healthcare power of attorney. A financial power of attorney, and I'm missing part of a parenthesis I see, you can only do a notary. So you cannot do witnesses for a financial power of attorney. It has to be notarized. And that's why when we do them in hospitals, we go into the room and we do both the healthcare and the financial power of attorney, and we notarize them both. So if the principal is unable to sign the document, and I get this a lot as well, the principal cannot sign. And I'm going to give you two different instances. The first one is going to be where the principal can't sign at all. So I had one gentleman who was shot in the neck. He was paralyzed from the neck down, could not make any signature. In those instances, the notary allows in Nebraska for the person to be able to nod his head or make some sort of sign that they want this document signed. As a notary, I can then sign the document on their behalf, but I then have to have two witnesses who witness me signing on the person's behalf, and then I notarize it as well. So just because someone cannot sign their name or cannot make a mark, there are ways under the Notary Act in Nebraska to get them signed, as long as you've got two people that will witness the notary doing it. Now I said make a mark, and what that means is, say I have somebody who had a stroke, and they can make a mark, they can make an X, they just can't sign their name. I can notarize that. As long as it's an acknowledgement, as long as I as a notary am noticing that the person is making the mark, is acknowledging they want to sign it, it doesn't have to be a signature. The notary is just acknowledging that the X is the person's signature for that particular document. And I have not had a bank question that, as long as it's been notarized. It's the other good reason to have a notary for these documents if you can, because banks tend to question them if they aren't done in a proper manner or an easy manner for them to tell them it's valid. So it has to be validly executed. You know, the only time that we've had trouble with getting these things validly executed is COVID, because if a document goes into a room with a COVID patient, it can't come out of the room with the COVID patient. So it has to stay there. So the way we've been able to do it is if we have a nurse who happens to be on the COVID floor and a notary, they can notarize the document and use one of the fancy apps that you can download and actually scan the thing right there in the patient's room, and then it stays in the patient's room. We've not yet found a way to do wills in patients' rooms who are COVID patients. Okay, so let's look a little bit about the distinctions between the healthcare power of attorney and a financial power of attorney. The healthcare one, the agent makes the decision. So Rachel's going to make decisions on my behalf, but only when I lose capacity, only when I'm unable to make decisions. Once I regain capacity, once I've come out of my coma, those decisions come back to me. And it's the physician who makes that determination. It's the physician, or, in instances, I know psych evals have been done in certain hospitals. So sometimes it's a psychologist will come in and do, if it's dementia or something of that nature, but a physician is the one who's going to make the assessment as to whether somebody has capacity to sign. The healthcare power of attorney is only in place when the person doesn't have capacity. The minute they have capacity again, they come out of the coma, then the decisions go back to them. The witnesses to the signature have to be some sort of, they have to be people who are not interested in the person's document. So it should not be, Rachel shouldn't be witnessing my power of attorney if I'm going to give her power, for obvious reasons. We don't want people wandering around and going in and signing their grandmother's power of attorney and then suddenly taking that document to go drain her vein. So the witnesses have to be two disinterested people. Again, you can have one person from the healthcare facility that witnesses, but then you have to have someone that is not a healthcare professional, and each hospital has their own things on whether they will even let one healthcare person sign off as a witness. The financial power of attorney, that deals solely with money and property. It has nothing to do with the healthcare, and it goes into effect, as I said, when it's signed and notarized. Once it's properly executed, it isn't that it goes in and out. It is in place right away, and Rachel could take that document right now and go to the bank once I've signed it and do things on my behalf. And again, as I said, it has to be signed in the presence of a notary. So when do they end? So I have a power of attorney, and I get this question all the time, is I will have hospitals who will refer people to me and say, this person needs a power of attorney, she's about to die, and the family needs to go do stuff once she dies. Nope. Once I'm dead, it's dead. It dies with me. The only thing that can happen after someone is dead and for someone to act on their behalf is they have to be appointed their personal representative under a will. So the power of attorney dies with the person who drafted it. If I die, my power of attorney is dead. I know the person no longer has authority. The other way is that if I revoke it. If I revoke the document, then it's done. And Nebraska is one of those, it's one of those legal documents where I actually have to, if I do a new one, it doesn't revoke the old one. I have to specifically say in the new one that it's revoking the old one before that is revoked. You can also put in your power of attorney that there is a period of time when it's valid and then it's going to terminate. So you can put in your power of attorney that this document is valid for 6 months from and after January 1st, 2021. Then it will automatically terminate on the date where you terminate. That's another way to do it. So when I talk about capacity, incapacity, competency, healthcare powers of attorney, a person can revoke that at any time, even if a physician has determined that they do not have capacity. So that's why capacity and competency matter when it comes to powers of attorney. The only thing that stops somebody from revoking a healthcare power of attorney is if a court has determined the person lacks competency. So if I am incompetent, and some people would argue I am, if I'm incompetent and I have a power of attorney, healthcare power of attorney, and I am angry and suddenly decide I don't want Rachel being my power of attorney anymore, I can say to the doctors, I revoke this. I no longer want Rachel acting on my behalf. And even though they have determined that I lack capacity, I have the legal right to revoke that. Now, what that means at that point is I don't have any power of attorney. And if I don't have a guardian, then you have to look at the Surrogate Decision-Making Act. And frankly, at that point, Rachel may be the one in line under the Surrogate Decision-Making Act to make those decisions. And then that's something the hospital has to work with. But that's the important thing to know, is that even if a person lacks capacity, they have the right to revoke their healthcare power of attorney. I've actually had guardianship cases where the judge determines that a guardianship is not necessary because the person has a healthcare power of attorney, but rules that the person is incompetent so that they can't revoke that power of attorney. So then a power of attorney remains in place and the person can no longer revoke that document, so that they don't get put in a position where they, again, need a guardian. So that's how powers of attorney came. So let's talk a little bit about powers of attorney and guardianship. There is a section, and Nebraska has both a standard power of attorney, a financial power of attorney document, and a healthcare power of attorney document. We use those documents for a couple of reasons. Number one, because they're pretty good documents and the Supreme Court of Nebraska has approved them. But secondly, because they've been approved, banks are less likely to question them because they're a document that's standard and they're used to looking at them. And actually, on a side note, since I don't put that in here, if you want to find those forms, I always say try to get some. Don't execute those without talking to somebody or really reading the instructions on what it is that you're executing, because they can give some very broad powers. However, if you want to find those documents and look at them, if you want to draft your own, they are found at the Nebraska Supreme Court website. If you look under forms, and I think they are under powers of attorney. They aren't under advanced directives. They're under powers of attorney. But they have fillable powers of attorney forms on the Nebraska Supreme Court website if anybody wanted to do this. So, powers of attorney and guardianship. Part of the section of the power of attorney form, the financial power of attorney form, actually allows you to say who you would want to be if the court needed to appoint somebody as your guardian or conservator. So not only does it allow you to appoint an agent, it allows you to say, okay, if I needed a guardian, this is who I want that person to be. The reason that's important, and what I tell people about advanced directives, is if you have both a healthcare power of attorney and a financial power of attorney, you should never need a guardian. There is only one instance that I've been able to come up with where a guardian is needed, even though a person has powers of attorney, and that is this. If someone has dementia or something where they have lost capacity, a healthcare power of attorney, financial power of attorney will not stop you from doing things. It allows somebody, so Rachel can go do things financially for me. She can go to the bank, she can sign checks for me, but if I start giving out my credit card number, or if I start writing out checks to people who are calling me on the phone, Rachel can't stop me from doing that under a power of attorney. That's why in that instance, you either need the court to determine that somebody's incompetent so they can't revoke it and take away that person's ability to write checks, etc., or you need a guardianship in place. It's the only time that I can think of where somebody needs a guardian, and it really is because you're at the point where you need to stop somebody from giving their money away and take more control than a power of attorney will allow you to do. If a guardian or a conservator is appointed, here's the difference between a guardian and a conservator. A guardian can do some minor things with your finances. If you've got, $20,000 and that's all you have, the court will just appoint a guardian for you because that person is allowed to do minor financial stuff. If you have a farm or a 401k that has $200,000, $300,000 in it, the court will appoint you both a conservator and a guardian, who's typically the same person. The only difference with appointing that conservator is there is a little bit more paperwork and a little bit more accounting that goes with it. The reason for that is the court obviously doesn't want you running away with my farm or my $200,000. And so when somebody has more money, the court will say, okay, we're going to appoint you a guardian to make medical and financial decisions, but we're going to appoint you a conservator to make sure that your financial stuff is taken care of. And that requires a little bit more paperwork that has to be turned into the court. So that's the difference between those two. So if a court appoints a guardian or conservator after the execution of a POA, so after I have a power of attorney, the agent becomes accountable to both the guardian and the principal. So if I get appointed a guardian, then whoever my guardian is, Rachel has to be accountable to both them and me. And the power of attorney actually has more power than the guardian. The guardian, if the guardian is appointed for me, it does not get rid of that power of attorney. All it does is put a guardian in place as well. The only time that a guardianship overrules the power of attorney is if a court determines that that's what needs to be done. So if somebody files, so let's say that Rachel's appointed as Rachel is my power of attorney. So Rachel's doing my financial stuff. My kids find out that maybe Rachel's taken my money, that Rachel is letting me live in squalor and she's taking my money and using it for other things. And I'm sorry, Rachel, for using your name. I'm making you look like a really bad person. But so let's assume, though, that my kids think that Rachel's doing a poor job. They can file to get guardianship over me and ask the court to get rid of the power of attorney. So at that point, the court just has to determine that Rachel's not acting in my best interest, and the court will revoke that power of attorney, and then the guardianship just takes over. So really, powers of attorney, if you think about it, have a lot of power. The court can't automatically just get rid of them by appointing a guardian. They actually have to determine that it's in the best interest that happen and revoke the guardianship. So when you think about who you're going to appoint as a power of attorney, it's important to appoint somebody that you know is going to act in your best interest, because the court does not typically look at what that power of attorney is doing. They don't have to report to the court on anything. Okay, so let's talk about the Advanced Mental Health Care Directives Act. Hold on a second. Did I talk about the Surrogate Decision-Making Act? I didn't. I need to go back. I missed one. So here we get to, what if you don't have a power of attorney or a guardian? And this is a surrogate decision-making act. As I said, a couple of years ago, there wasn't anything in Nebraska that allowed for someone to make decisions for me if I lost capacity and did not have either a guardian or a power of attorney. And I think it was 2018, the UNICAM passed Nebraska Revised Statutes 30-604, which is the Surrogate Decision Making Act. And what that does is it gives a hierarchy of individuals who can make decisions if my physician determines that I'm unable to make those decisions. So it doesn't override a power of attorney or a guardianship. If either of those documents are in place, this statute doesn't matter. If those documents aren't in place, though, that's when this statute kicks in. And so the hierarchy starts with your spouse. So, it's very counterintuitive to think that if this law was not in place, my spouse couldn't automatically make my medical decisions if I didn't have documents. But that's kind of how Nebraska was prior to this statute. So the spouse is the first person. If you are legally separated or pending a divorce action, then they don't count. They will jump over that person and go to your adult children. And it's any of your adult children. So if you have 4 adult children, then it is all of them. If they're unable to make decisions, then it's the hospital that is doing this. So the hospital can actually jump over them and then choose your parents. So if my 2 kids can't agree on what's going to happen with me and they're fighting, the hospital can actually jump over them and say, okay, well, we're going to talk to your parents. Well, both of my parents are deceased, so they would then go to my siblings. I have 8 siblings. So as you can see, this is a good law because it at least allows the hospital to go to somebody to make decisions. But it's not a perfect law because obviously if my 2 kids can't get on board with what should happen with me, my 8 siblings are certainly not going to be able to come to a resolution. And I do want to go back for a second to healthcare powers of attorney, because this particular slide reminded me of something else that I usually talk about when talking about those documents. And that is who you should appoint as your agent. I will have clients come to me and they have, just like I do, 2 kids or 3 kids or 4 kids. And they will say to me, I want both of my children to be my healthcare power of attorney. I won't draft documents that do that, for the very reason of what we're talking about under this act. Say that I've appointed both of my adult children, and so they have the same decision-making ability under a healthcare power of attorney, and they can't decide what should be done. It's kind of a side funny story in trying to choose who I was going to appoint, because my kids are my alternate. One of my kids is my alternate healthcare power of attorney. I said to them, who would unplug me if it needed to be done? One of them said never. The other one said, I'd do it. She's the one that's my healthcare power of attorney. But that's the problems that we run into. I have one particular sibling that I know never would have made the decision to withdraw life-sustaining treatment on my parents. And so I was appointed as their healthcare power of attorney. So you have to think about those things when you're doing a healthcare power of attorney. And the reason that I won't draft healthcare powers of attorney that have 2 people with equal, I will do alternates. So my husband is my healthcare power of attorney. If he is unable or unwilling to make those decisions, it goes to my alternate. And I draft documents that way, because then you don't have a hospital who's thinking, okay, my one daughter is saying, go ahead and withdraw. My other daughter is saying, absolutely don't withdraw. Then we're back at a point where really nobody can make decisions because the hospital doesn't know what to do. For financial powers of attorney, I will do 2 in that instance, because, say I have a lot of stuff to do. My kids then would have equal authority. They don't have to agree on things. They just have to, they could both go make those decisions and get things done. So very important, healthcare advanced directives. I do not let people appoint more than one person as their primary agent, because it's like not having a document at all if you can't get those people on board. The question also becomes, if you have 2 people on it, does the hospital need to consult with both of those people before they would make decisions? It's the other problem that comes up. Say that they need to do immediate surgery and they can only get a hold of one of my agents. So when you're talking about powers of attorney, and if you have patients that are asking about it, because I know that as health agents, you guys will do healthcare powers of attorney, that's my stand, is that I won't do it, and for that reason, because it really does make things more difficult for the hospital and frankly for the family. I know that feelings can get hurt if one person is chosen over the other, but it's worse when you have 2 people fighting in the lobby because they can't decide who should make the decisions. Okay, so back to the Surrogate Decision-Making Act. So under the Surrogate Decision-Making Act, it goes to spouse, then adult children, then parents, then siblings. Then it goes to any other person that has or knows what this person would want. So, in this instance, say they can't get a hold of my husband, they can't get a hold of my adult children, they can't get a hold of my parents are deceased, they can't get a hold of any of my siblings, but they know that my friend Sandy would make decisions for me and they have her contact information. They can actually jump to her if they can't get a hold of her. And as a last-ditch effort, it actually allows the physician, not the physician who has ruled me to lack capacity. So if I have a physician who's come in and said, okay, Ann does not have capacity to make decisions, that physician cannot be a surrogate decision maker, but another doctor at the facility can, for obvious reasons. They don't want somebody saying that I'm nuts and then, making decisions to withdraw sustaining treatment or do whatever. So, I always tell people the law is very logical for the most part. Courts don't often rule logically, but the law written is typically very logical. So it makes sense. If you think about it, okay, let's go to the spouse first. So this law, really, when it went into place, what it really looked at, because it doesn't, again, allow for financial decisions. It doesn't allow somebody to take care of my finances. It just allows them to make medical decisions. So it doesn't solve the problem of the finances, but at least it solves the problem, for the most part, about medical decisions. It also allows, this particular law allows for placement decisions. So if I'm in a facility and I need to be transferred to a skilled nursing facility, or a SNUF, as you guys call it, it would allow my surrogate decision maker to make that decision, and actually sign me into a skilled nursing facility or rehabilitation facility, et cetera. It allows for that as well. When this law was first put in place, what it really was anticipating was adult disabled children whose parents were the payee of their Social Security, and that was really all the financial stuff they had, and really all they needed to do was make medical decisions. Or the other realm of things, where when you have married, spouses, everything is jointly owned, so the spouse can do all the financial stuff. They just really need to be able to make medical decisions. So for those two schemes of things, it really has been a very good law. The reason that it isn't a perfect law is because it doesn't allow for financial stuff, and it doesn't allow for end-of-life decisions. So it does not allow the surrogate decision maker to determine to withdraw or withhold life-sustaining treatment. The reason for that is, if it allowed that, it would be in direct conflict with the same statute that talks about the healthcare power of attorney. So that is one of the bad things about this law, is it will let you make every medical decision except life-sustaining or life-withdrawing treatment is not allowed. Okay, let me jump to the Advanced Mental Health Care Directives Act, which is brand new. It was passed this year by the UNICAM. The way that the UNICAM writes things is stuff goes into effect, unless it goes into effect immediately because it's declared an emergency. It goes into effect 90 days after the end of the unicameral session. I don't know if you guys all know this, but we had 2 unicameral sessions this year because of the pandemic. They stopped, they went in recess, they came back. So my best guess is that this went into effect in December. So December of 2020 is when I'm guessing that this went into effect. It may have gone into effect sooner, but we all know for sure at this point it is in effect. What it does, it is a healthcare directive that allows the person, and somebody who has a mental illness, that goes in through phases. So someone that is often being taken to the hospital because either they stop using their meds, the meds aren't working, somebody that often has exacerbations of their mental health, and ends up in a facility. It allows them to make decisions about what will happen to them next time they end up in the hospital. And so it avoids a guardianship for that reason. So its purpose is to prevent unnecessary and involuntary commitments and incarceration. It's supposed to improve mental health. But really what it is gives the patient the right to make decisions on what's going to happen to them. So what does it do? It allows that person to consent to or refuse specific types of healthcare treatment. So they can say, actually, in that document, if I end up in the hospital and you think that I need inpatient mental health treatment, I'm going to agree that you can put me in inpatient mental health treatment. And I don't remember the length of time. I want to say that it's for up to 3 days. It's either 3 days or 2 weeks. I don't know why those numbers are sticking in my head, but it allows them to say, okay, against my will, if I come into the hospital and I have this document, I'm going to let you commit me to an inpatient mental health facility. I'm going to allow you to give me psychotropic medication or electroconvulsive therapy. They have to specifically put in this healthcare power of attorney that they're agreeing to the electroconvulsive therapy. It isn't something where they can just say, yeah, go ahead and treat me. It's something where they have to specifically say, I consent to this. It also lets them say what treatment facilities or care providers they want. If there's a doctor they really like, they can say, I want this person to treat me. If it's a doctor they don't really like, they can say, I don't want this person to treat me. Alternatives to 24-hour care, if they want that. Again, they can pick what medication they want, what specific medication. They also can pick what emergency interventions they want, including restraint or medication. The legislature, although they passed this statute, did not come up with a form. They've not yet come up with a form for this directive. My office did. My office worked in conjunction with the person who actually was the person who was the impetus for this law being brought before the UNICAM. And we've developed what we think is a pretty good form for this that I've been giving to the hospitals and telling them to run through their ethicists and their in-house counsel. But I think that it meets everything that's required. You know, our hope is that what this will be used for is when someone is in a facility, they have been brought in, they finally are at a point where their medication is stable and they have capacity. We're hoping that hospitals will then present this document and help the person fill it out. There isn't anything in the statute that says whether it's akin to a healthcare directive that hospitals should do it. In talking to some in-house counsel for hospitals, we believe that it is akin to a healthcare power of attorney and that healthcare workers can help patients fill this out. The good thing about it is, so let me tell you what else is in it. So it releases it, within it gives it a HIPAA release, so you can state the name of the person you want stuff released to. So say that I am inpatient and they've invoked this document and I have in there a HIPAA release that my medical stuff can be released to Rachel. So then they can call Rachel and say, hey, Ann's been committed. She has this healthcare directive. She says that we can release information to you. So this is what we're doing. So even if I haven't appointed Rachel, which I can do under a separate healthcare power of attorney to make those decisions, it says that, you know, you can release information to her. It also says who should be contacted immediately upon admission to an inpatient facility. So if I put in there, you know, contact my children, contact my husband, the hospital then has information on who should be contacted if I'm inpatient. It also tells who should be allowed to visit and who shouldn't. Say I have somebody who's a trigger. I can put in there, if I'm inpatient, absolutely do not let my mother-in-law, do not let so-and-so be allowed into the healthcare facility. I do like my mother-in-law, I'm just joking. So here's why the important part of this advanced care directive. It allows somebody to say whether they want this document to be irrevocable during times of incapacity. So remember, when I talked about healthcare powers of attorney, I said that unless a court determines that you are incompetent, even if you lack capacity, you can revoke your healthcare power of attorney. This document actually allows somebody, when they have capacity, to say, if I lack capacity, I am saying this document is irrevocable. I am saying I am not allowed to revoke this document if a physician has determined that I lack capacity. Because of that, you know, when someone is having an exacerbation of their symptoms, they've been off their meds, they are being hospitalized, and as part of this document, they say, you can put me in inpatient treatment. And they are now saying, nope, I don't want to go to inpatient treatment. I'm revoking this document. If they put in that document that it's irrevocable, it's irrevocable. And they can't at that time revoke it until they have again regained capacity and a physician determines that they have capacity. At that point, if they want to revoke it, they can. But that's the very good thing about what I believe this mental health care directive is. It really allows somebody who otherwise, you know, is in a facility and suddenly, you know, is off their meds and keeps getting put in facilities. These are people that we often will end up doing guardianships for, and then we end up dismissing the guardianship down the road because they've regained capacity. Then they go back in the facility, they don't have capacity, you file another guardianship, they're back out of facility. And so for these kind of circular individuals, this has really been a great addition to the bills and to the healthcare directives. And so they're brand new. Most hospitals are just learning about them now. So I'm trying really to get the word out. If I don't think that I've sent the form to Methodist yet. I probably should send it to somebody over there, just so that the hospital has a form that they can look at and decide whether it's one they're going to use, whether they're one they're going to edit. I don't know whether the Supreme Court at some point will come up with an actual form for this. I'm hoping that they will use our form. We went through a lot to get it to the point where it is. But it's a good form. It's a good law. The laws they have right now are not perfect, but really over the last couple of years, they've really come a long way in doing things that make it easier for hospitals to not have to try to figure out, okay, what can we do in this instance? So I have about 12 minutes left. I'm going to leave this open for questions. I know that I did not cover guardianships as part of this presentation, but if you have additional questions, how do guardianships play with this, et cetera, or you have just general questions, I'll take those now.
Thank you for the presentation. I actually learned a lot, so thank you so much for all that information.
I'm sorry for using your name and saying that you were bad. And
it's all good. I totally understand. I know for a while I was like, gosh, I'm a really awful person. But no, I understand. So we do have a question about competency. So does it make a difference if a physician documents that someone is not competent to make decisions? Does that become a factor if a documentation from a physician is made?
No, I mean, no, because they still don't have the ability to rule on competency. And it's, again, when I talk about that the words competency and capacity get tossed around a lot, I think everybody thinks they're the same word. I guess if you look them up in the dictionary, they probably are, but legally they're not. So the way that I would look at it is if the physician says that someone lacks competency, what they mean is they lack capacity. And it isn't until a court has made that legal ruling about competency that legally that would have any effect. Don't tell doctors I said they don't have authority to do that, but they don't.
We won't. I do have another question, and then that was all that I had for questions. But if someone is thinking of a question and they can unmute their microphone and ask once I'm done, that's fine too. So going back to signing on the behalf of someone, does that vary state to state?
It does. I mean, it's because it is a notary regulation. It's under the notary statutes. And so I don't know what the rule is in Iowa or anywhere else. I just know that as far as Nebraska is concerned, notaries are actually a statutory, I have to take a notary test, et cetera, but it's pursuant to statute that allows notaries to do the things that they do. So we have a special notary block that we use when we've got to sign for someone who's unable to sign. When somebody's able to make a mark, we're able to use our regular, we just notarize it. But we do have a special notary thing when they're unable to sign at all.
Thank you. My mute and unmute button is delayed a little bit, so sorry about that. We do have a question about capacity that comes and goes for a patient, and can a doctor revise capacity?
So they can. I've had instances where the doctor says they don't have capacity, and then the next day they do. What's harder is when you have individuals who are sundowners. So they have capacity in the morning, but not in the afternoon. And in those instances, when you're talking about doing powers of attorney, I had somebody ask me, how do you as an attorney decide whether you're going to let someone sign them? I take heed in what the doctor says, but if the doctor says the person usually understands in the morning but doesn't in the afternoon, when I stop on the floor to do the power of attorney, I check in with nurses, and then I do my own kind of check-in with the patient. Just ask them, do you understand why I'm here? Do you understand what we're doing? I have no problem executing a power of attorney with an individual that does have, points of capacity to be able to sign and understand, even if in the afternoon they may not understand. As long as they understand at the time I'm meeting with them and they have capacity, then they can sign those documents. You're muted, Rachel.
Thank you. I thought I hit it. We do have another question regarding can mental health care directives act cross state lines, such as an admission for psychiatric hospitalization in Council Bluffs?
That's a really good question. And I hate when people say that's a really good question, but it is. So typically what I say to individuals when it comes to healthcare and financial powers of attorney, and so I'm going to have to be making a educated guess at this. If I draft a power of attorney for an individual and it's executed properly in the state of Nebraska, then it's taken to Iowa under the full faith and credit clause, and it's the only time I get to quote the Constitution. Under the full faith and credit clause of the Constitution, that document is valid in Iowa. It has not really been addressed because, again, this is a brand new law in the state of Nebraska. I do not know whether if it is properly validated, if it's properly executed here, I would say yes, that it would be valid. I will say that I think Iowa has a similar sort of law, I've been told. But I would say that it is valid. My only caveat to that is going to be because the document allows for inpatient mental health treatment, I think doctors may knee-jerk be a little concerned about it if it isn't something their state is used to dealing with. So I would argue that constitutionally it's valid. Whether a hospital would necessarily follow it because they haven't dealt with it before and they're not sure without checking with their in-house counsel, I can't answer that question.
All right, good point. Another question is what does a doctor need to do to reserve a capacity decision? Or does your decision that the person had capacity when you assessed the patient trump an earlier doctor's decision that the patient did not have capacity?
Okay, so I need to clarify. If a doctor has determined the person does not have capacity, I will not meet with them. Because at that point, if the doctor determines there's no capacity, I won't do it. Typically, what I'm talking about is in situations where a doctor says they do have capacity, but in the afternoons they may not. So it'll be one of waning capacity, where the doctor will say, I think they have capacity to understand medical decisions in the mornings. So that is not a blatant, this person doesn't have capacity, and that's where I would use, my assessment, because the doctor hasn't said, no, this person doesn't have capacity. They say that it wanes, and sometimes in the afternoon, they're worse than in the morning. As far as in general, if the doctor has said this person does not have capacity, the doctor would need to note in the chart if they've reassessed and have now determined the person does have capacity. It would require a reassessment by the doctor and a note in the chart that they have now determined the person has capacity before decision making would go back to them.
Thank you. All right, another question. I've seen cases where a patient has a comprehensive cognitive evaluation and writes that the patient has dementia. The physician then states that it is time to invoke the person's power of attorney for health. At that point, can the power of attorney health really be initiated, or does a court have to validate that the person is incapacitated?
No, that's a doctor decision. If the person has a valid healthcare power of attorney, then it is the physician who determines incapacity in order to invoke that document. The only time competency would be necessary for a court to do anything is if you had an incapacitated person who suddenly wants to revoke that document and say, I don't want that person to be my power of attorney anymore. That's the only time you would need to get the court involved. But it's the physician, as far as invoking a healthcare directive, that makes the decision with regard to capacity and whether the document can be invoked. Invoke and revoke. I have to watch not to cross those over.
All right. Those were the only questions that we had in the chat box, and we are almost at time. Is there any final questions that anyone had that they want to unmute themselves or quickly chat it in the chat box and I can ask? We have just a few minutes left.
And if you come up with something afterwards, if you think about something, please email me and ask. I'm always happy to clarify questions for folks if they come up with something at a later time. Or if something pops up in your practice and you think, oh, Ann said something about this, what was it? I'm always happy to answer those questions too.